And we are working our way through the United States Constitution line by line. I'm Don Frazier.
I'm Paul Fabrizio.
And we are now examining the Sixth Amendment to the U.S. Constitution, which we've broken into 6 parts. This is the third of the 6 parts.
So when we get to the 10th, we're going to break it into 10 parts?
I don't think this is a trend.
No.
But these are complicated amendments that had a lot of components to them.
Right.
So what's this particular piece?
Okay. So in all criminal prosecutions, the accused shall enjoy the right to be informed of the nature and cause of the accusation.
So you just can't hold somebody
Right.
indefinitely without telling them what they're being charged for. Now, how's this different than habeas corpus?
Okay, habeas corpus is actually mentioned in the body of the Constitution, and now I forgot which part, but it's in one of the articles in the Constitution. And habeas corpus means show the body, so you have a right to go before a judge, and hear the case against you.
Yeah.
And hear the charge against you, and that's typically arraignment. Okay? This is arraignment, but it can go beyond that, and this allows the defendant to hear the evidence against them. Okay?
Okay.
So this is where it goes beyond that.
Not just being charged, but you also get to see the evidence.
To be informed of the nature and the cause of the accusation. And one of the things about our system is that the prosecution must turn over to the defense the evidence that they're going to use. Okay?
I bet that's pretty rare in world legal systems as well. Or was historically.
Yeah, historically I'm sure it was. Hopefully more countries have this. I mean, what it prevents is, a great deal of drama in the case. You want both sides to have an equal shot at winning their case.
Sure.
Winning either conviction or found not guilty.
So is this all part of what's termed discovery?
Yes.
Okay.
Very good. And so that's what you do. You get that chance. So the prosecution can't all of a sudden in the middle of the case pop out a surprise witness and plop him down, and the defense has no opportunity to know about it before it happens.
And prepare their questions or even come up with a strategy for how to deal with them.
Right. Now, by the way, this only works one way. The defense has no obligation to share theirs, evidence, theories, with the prosecution.
Really?
So it's a one-way thing.
No feeling.
Yeah. Okay? The government has the burden of proof in these cases. The government is trying to prove someone's guilty. And the government then is going to take that person's life, liberty, limb, whatever, property.
Limb. Trailer hitch, whatever.
Yeah. So therefore, the government has the heavier burden in this thing.
Oh, wow.
And so the defense, they take what the government gives them, and then if they develop something on their own, they develop something on their own.
Wow.
So
interesting angle on it.
So when you're watching TV and you see a criminal case that's unfolding in TV, usually the surprise comes from the defense side.
Dun, dun, dun.
Yeah. Perry Mason as an example. Because they're the ones who have more opportunity to spring that surprise. Mm-hmm. The prosecution, these are the witnesses, this is what took place. They share everything with the defense.
Scarface was in my cafe having dinner at the time.
Yeah.
He couldn't possibly have been there.
Yeah, exactly.
That sort of thing.
Okay.
Interesting. All right, so that's pretty succinct.
Yeah.
Not much to talk about there.
But it says a lot.
But it says a lot. And it tells you kind of, once again, that the citizens of the United States are given a little extra leverage when it comes to these things.
Against the big bad government.
Against the big bad government.
Okay.
I'm starting to be convinced that you have to be a really bad hombre to get convicted.
My understanding is that most of the people who are arrested in the United States are in fact guilty. And as a consequence of that, very seldom do trials occur.
Huh.
Because the people are guilty.
Yeah.
And you begin the process and the defense sees the evidence and they go,
calf rope, we're done.
Yeah, I'll make a deal. And in some jurisdictions, my understanding is that 95% of the people who are arrested are guilty. And then why do you have a trial if you're guilty? Often people will plead guilty or they'll plead not guilty at the beginning, but then a little further down the line, they'll negotiate and get a guilty plea and don't go to trial.
Interesting.
I remember 2 years ago, I had a visitor here from China, and she was a professor, and we wanted to see a trial. And
I bet it was a rare thing for her.
We waited for weeks and weeks for a trial to take place.
Wow.
And they weren't taking place. And I talked to someone at the courthouse, and they said, everybody's pleading guilty. No trial.
So there you have it.
There you have it. I finally took her to an arraignment instead.
All right, so that's that part of the Sixth Amendment. We'll come in with part 4 next time.